Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing consent and sexual assault. This can be upsetting material for a lot of viewers, so please make sure that you and whoever's in the room with you are comfortable watching this material. Consent is required for sexual activity, but what does that mean when sex is consented to on the condition of condom use? If a woman gives consent to sex only if her partner wears a condom, is it sexual assault if he sabotages a condom, removes it partway through sex, or disregards this condition? That's what happened in a case currently before the Supreme Court. This is something referred to by some as stealthing, not wearing a condom when your partner believes you are wearing one, including removing the condom midway through sex. The case involves a BC man, Ross Kirkpatrick, and a woman he met in 2017. They had sex twice in one night, and the woman insisted that Kirkpatrick wear a condom. He did the first time, but the second time, unbeknownst to her, he did not. He was charged with sexual assault. What's the current law in Canada about how conditions like this impact consent? Here today to discuss the law and the case are two criminal lawyers. Sarah Lehman is a criminal defense lawyer from British Columbia, and Angela Chasson is a lawyer focused on sexual assault cases in Ontario. Thank you both so much for joining me today. Now, for both of you, I outlined the facts and the background of this case here. I'll start with you, Sarah. Is there anything you want to add to the facts as I described them?
Yeah, I think it's important to point out that the facts in this case involved a complainant who was very specific about the condom usage. There was evidence to say that she had asked to see the condom, and there was also evidence to say that the accused person had moved over to get a condom out from the bedside table in the first instance, and then made the same type of action in the second instance.
Like kind of faking that he was getting one.
That's right. So I think that that's a very important facet of this case.
Angela, anything you want to add to the facts or background here?
The issue here really turned on the issue of deceit. Whether there was evidence of deceit such that the consent would be vitiated by reason of fraud. And so it's a technical legal point that I hopefully won't bore your listeners too much, but an issue really became clear on appeal about fraud under 265 of the code versus informed consent under 273 of the code, and where the facts here fit in.
So let's get into what the lower court here held. The accused, Kirkpatrick, was originally acquitted, and the judge found that the complainant had indeed consented. What can you tell me about that, Angela? About that lower court decision?
So he was found not guilty at his trial. The judge said that there was no evidence of deceit. Under a previous case, a 2014 case, setting out that deceit, fraud requirement to vitiate consent. And then the appeal court opted 2-1 to order a new trial. So the issue was, she consented to sex, but on a precondition. And was that precondition not met by reason of deceit? So again, really technical, not normally the way that we would think about full, informed, and free consent under the law.
Sarah, anything you want to add to what the lower court and maybe then the Court of Appeal found here?
Yeah, I find it interesting that the Court of Appeal decided to, of course, overturn the decision of the trial judge, but that they did so for different reasons. So you have one Court of Appeal judge who's saying, yes, this constitutes sexual assault because there was a condition precedent to the sexual activity that this complainant had consented to. That condition precedent wasn't met. While we have the other two judges going through the fraud analysis. So it is very interesting to see, different judges coming to the same conclusions for different reasons.
Now, we've got to go to commercial break in a bit, but when we come back, I want to talk about the existing case law here, because there is existing case law on condom use specifically and about fraud. And I think in that case, it involved some pretty disturbing details of the accused, the man had poked holes into a condom, and the analysis from that case had been imposed onto this case. And we're going to see if the analysis lines up or if there's something slightly different that happened in those two cases. We've got to go to commercial break, but we will be right back. Welcome back to Canadian Justice, where we're discussing a case involving sexual assault and condom use. It's at the Supreme Court. A warning for our viewers that this episode does involve descriptions of sexual assault. Angela, I want to follow up with you about this existing case law, which some of the lower courts relied on, a case called Hutchinson, which dealt directly with condom use and consent and the notions of fraud being used in obtaining consent. That was a case where the accused, the man, had poked holes in a condom. What can you tell me about that particular case and how it was applied in this case?
Absolutely horrifying case. In Hutchinson, the issue was a sabotage condom. So the perpetrator was actually wearing a condom, but he had poked holes in it. And his sexual partner actually became pregnant as a result of that. So just absolutely horrifying facts. So in Hutchinson, 2014, not that long ago, still pretty long ago, it was a sabotage condom versus disregard of a precondition, what Sarah was saying is a condition precedent to consent. So the question really was, does the condom or no condom transform the physical act, the physical sexual act, and bring it into the consent analysis, right? I'm only consenting if you do this, versus the fraud analysis. Consent is vitiated by deceit.
Sarah,
so big
sorry,
legal
continue,
analysis. But no, just it's It's a really technical area, and I apologize for interrupting. The reason it drives me bananas is, we're kind of up here, the lawyers are up here, the judges are up here talking about, section 273 versus section 265 and where this fits in. And meanwhile, women are getting assaulted, right? Women are being raped, women are becoming pregnant, women are not having their sexual needs listened to or their sexual health respected. So it just kind of drives me crazy that this technical area of the law has become the focus, as opposed to, what we mean when we talk about consent and the need to listen to women.
Sarah, I want to follow up with that on the notion of consent and condom use. Is the notion of consenting to sex with a condom inherently different if a condom isn't used? Is it inherently a different act?
Well, I think that that's the big question that our courts are grappling with right now. It's the question of whether or not we can build in particular conditions to a sexual act. So that is the big question mark. And again, I echo Angela's frustration with a lot of this, because it seems as though we have established all of these different onerous legal tests in order to get to the same conclusion. Is it sexual assault? It makes some sense in the Hutchinson case why the Supreme Court of Canada decided to apply the fraud analysis, given the facts in that case, which were very out of the ordinary. This wasn't a case, as you said, where the condom was removed, but rather a case where the condom was altered in order to render it ineffective. So, it gives me some comfort that our courts are going through those steps in order to secure conviction where there is moral culpability, as in my view, there was in Hutchinson. But, it is frustrating from the perspective of complainants who find themselves in these positions.
Now, Sarah, but is fraud even the right analysis to be applying here? I mean, in this case, I guess, based on the facts that you added in the first segment, that there was kind of this move to make it look like he was reaching for a condom. But does that even would that rise to the level of fraud, especially compared to what happened in Hutchinson, where there was this very deliberate tampering? Or is fraud even not the right standard to apply here? Because this was a condition that was asserted and then sort of disregarded during the second time this couple had sex.
Yeah, I think that fraud feels a little bit clunky in these types of analysis, right? Like, we're talking about a sexual act here. We're talking about human behavior. It doesn't lend itself to these types of legal tests all that well. Now, that being said, there does have to be some element of deceit. And I think that was certainly there in Hutchinson. The question is, was it there in Kirkpatrick?
Yeah, and fraud is a high standard, right? Fraud goes beyond just deceit, and this is an incredibly high standard that I don't know how it could properly apply in this case, and I think maybe there's a different analysis that might be needed for cases like this. When we come back from this commercial break, we're going to continue this conversation. Welcome back to Canadian Justice, where we're discussing a case involving sexual assault and condom use. I want to let our viewers know that if you're uncomfortable with this topic where we discuss the details of sexual assault, you might want to change the channel. I want to get into what the court was asking in this case, which was heard before the Supreme Court recently. One of the questions that was asked by Justice Rowe was, he held up his wedding ring and he asked if he were to put his wedding ring in his pocket, whether that would vitiate consent, if that's comparable to sort of lying about condom use. Because without a requirement to prove fraud, which is the current standard, some incidents, like lying about marital status, would be criminalized when they shouldn't be. And of course, lying about your marital status is wrong, but it doesn't rise to the threshold of a criminal offense. A lot of people would be in jail if it did. So what can you say to answer Justice Rowe's question about expanding what type of conduct might vitiate consent in a sexual assault case? Sarah.
Yeah, I mean, I obviously have concerns as well about laws being drafted or interpreted in an overly broad manner. So we don't want to criminalize behavior that shouldn't be criminalized in the first place. That being said, I think that removing somebody's wedding ring, lying about marital status, those types of things don't constitute part of the sexual act and therefore don't go to the issue of consent with respect to that act. So that would be my answer to that question.
Angela, I want to ask you the same thing, but I want to add to it about how this analysis might apply to, for example, pharmaceutical birth control. In the Hutchinson case, it involved tampering with a condom use. If a man consents to a woman who says that she's on birth control, but say she isn't on birth control, that does go in part to the sexual act. Would that vitiate consent?
It's such a great question. And what we often see judges doing, right, is they go to sort of one extreme in order to figure out how they're feeling about a certain situation, almost acting as devil's advocate. With respect to Justice Rowe, I don't think that the devil needs an advocate on this point. His colleague, Justice Jamal, was very quick to jump in and say, no, we're talking about physical acts here, which is just what Sarah articulated so well. Right, we're talking about the physical acts, not lying about marital status or whatever other people do. We're not going to say that every time you have sex and perhaps regret it, that should be criminalized. So that vitiation of consent, that fraud part, it is limited to physical acts. And I don't even need to go there. Justice Jamal handled it extremely well.
But what about the analogy to pharmaceutical birth control?
Yeah,
I think.
Oh, sorry, Angela.
Go ahead.
Jump in very quickly on this one. I think that it's important to take this out of a heteronormative context as well. So when we're talking about condoms, a lot of the times our courts talk about the prevention of pregnancy, prevention of disease. I think it's important to separate those things. Condoms are often used in order to help with safe sex, not in pregnancy prevention, absolutely, but also in the transmission of disease. So I think if we look at it from that perspective and change the narrative from pregnancy prevention to safe sex, I think it would make a bit more sense.
Angela, anything you want to add there?
I think that we do. I absolutely agree with Sarah. I do think it is important on top of that to recognize that cis women and cis men do face different risks when it comes to sex, pregnancy being one of them. And the law recognizes pregnancy as being a risk of bodily harm. Pregnancy still can wind you up in the hospital. It can wind you up in a morgue if things go wrong. And I think that even in a country like Canada, where access to abortion is so limited for so many communities, especially First Nations and rural communities, that we do need to recognize the different effects to men and women and the fact that sexual assault still disproportionately happens in a heterosexual context where women are affected much, much more than men.
We've got to go to commercial, but in the next segment, I want to ask about reasserting conditions on consent. So this condition was asserted the first time they had sex. The second time they had sex, they kind of woke up in the night to have sex again. And I want to ask you if that condition, if it's a condition you have as a part of your consent, if you need to reassert it each time, or is the first time assertion enough? We've got to go to break, but we will be right back. Welcome back to Canadian Justice, where we're discussing sexual assault, condom use, and consent. A warning for our viewers, we are discussing details of sexual assault in this episode. Angela, I want to ask you a question about reasserting a condition on consent. Obviously, the first time this couple had sex, the complainant asserted that condom use was a condition, but does that condition need to be reasserted each time? Or is the assertion of that condition the first time enough until, and it remains in place as a condition until it's expressly removed by her? What's the law in this?
I think that there's two issues there. The first is on the facts of this case, because the sexual activity was, hours apart. It's not years apart where parties meet up again and need to, reestablish their boundaries or their preconditions to consent. So here it's a little bit because the temporal nexus is so tight that I think it would be, in my opinion, absurd to require those preconditions to consent to have to be stated every single time. Once you've limited your consent to how you want to have sex, that remains in place until you say otherwise.
Sarah, I want to turn to you about the impact of this type of conduct on victims, because I want to make sure we're not focusing this on, the experience of the accused, who are in these cases generally men. Do you have anything you want to say about what the impact this type of behavior, non-consensual condom removal, would have on women who are victimized by this type of thing?
Well, I think as we see in the facts in Kirkpatrick, it can have a very profoundly negative impact on a person who falls victim to this. I think that the distinction between sexual assault, for something that you didn't consent to in terms of the act versus sexual assault, something you didn't consent to in terms of condom usage, is kind of the same from a victim's perspective. It is degrading, it's disrespectful, it places the person at risk that they did not necessarily want to assume. So I think that really at the end of the day, from the victim's perspective, it's really all one and the same.
And Angela, I want to follow up on sort of a similar vein, because some of the people I've talked to, non-lawyers who I've talked to about this case, men and women, have tried to get into the head of the accused here, which is never a great idea to do. But a lot of people talk about this as, it's a sensation thing. It like feels better to have it off. But I think that there might be more to the psychology of a perpetrator who does this. And I want to know if you can add anything to why people might be doing this kind of thing.
Well, it's kind of amazing that I often hear, straight men say, oh, the condom dulls the sensation. And then the next breath, they'll say, oh, well, the condom fell off and I didn't even notice. So I just kept going. Come on, guys. The fact of the matter is that sexual assault is not about sex. It's about power and it's about control. And I'm just going to say it again, because if there's one thing I know doing this kind of work, that's it. Sexual assault is not about sex. It's about power and degradation. And that's what's in the mind state of the people who are doing this.
And Angela, just to follow up, do you have any sense of how common this phenomenon is? And is it on the rise? This was the first I'd heard of this term, stealthing. But is this new, or is this something that's increasing and people should be aware of?
It's not new. I recall even almost 10 years ago in the gay community, a lot of men were talking about this act of stealthing, of removing a condom partway through sex, which in my opinion is right up there with poking holes in a condom in terms of deceit. So unfortunately, it's been around for a while. I expect it'll continue.
I want to thank you both for coming on today and sharing your expertise and time.
Thank you.
We've heard today about the disturbing trend of stealthing or non-consensual condom removal during or even before sex. This is a disgusting practice that should be condemned by society, as it disrespects and objectifies the person who's been requesting condom use. And now the Supreme Court will determine if it's not only worthy of moral condemnation, but also of criminal sanction as sexual assault. What will the court decide? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.